pray. We pray, Lord, for wisdom. We pray for guidance, and we pray that we will move with alacrity and that everything will be done in good order and to the glory of your name. In Jesus' name we pray. Amen.
Amen. Thank you. We have some apologies for absence from Senator Morgan, Senator Scott Motley, and MP Dalrymple Philibert. So welcome again. You should have, well, in front of you, you should have received the minutes, and that would have been the minutes of the meeting, not last week because we didn't have a meeting. It would be the minutes of, what date again? November 13th? November 13th. And you should also have a summary sheet of the decisions made by the Committee on Clauses 1 to 77. Additionally, on your desk today is additional research that was done by the technical team, and we will go through this as well. So we'll move to reading and confirmation of the minutes for the meeting held on November 13, 2019. Go through page by page. Page by page. All right. So page 2 of the minutes. Any corrections or helpful additions? Okay. Page 3. Page 4. Page 5. Page 6. Page 7. Page 8. Page 9. Page 10. Page 11. Page 12. Page 13. Finally, page 14. Do we have a confirmation, please? Moved by Senator Samuda, seconded by Member Robinson. All right. So we will move into matters arising from the minutes. So Ms. Murray, you want to? There are many matters arising from the minutes. Huh? The two schedules. Okay. All right. We're going to defer the matters arising. We will finish the two schedules, and then we'll go back to matters arising from the minutes.
Minister, Chairman, even though you're deferring matters arising from the minutes when we do take it, there's some clarification I'd like on the deliberations we had on Clause 71 read MAJs. what MAJ had put forward.
All right. All right. Third schedule. It says the first schedule. 4. Okay. So we have, in terms of the schedules, we have schedule 1, 2, and 4. So Ms. Murray?
Thank you, Chairman. Good afternoon, members and everyone else. So on the first schedule, there was one comment from /Roots, and it was a recommendation that the term of any single commissioner be limited to 2 terms. We direct the committee's attention to the fact that at paragraph 2, subparagraph 4 of the schedule, the commissioner vacates when she or he attains the age of 65 or completes 10 years of service, whichever is earlier. So 170. So that recommendation from /Roots is essentially already addressed. And that was the only comment from a stakeholder, but we direct the committee's attention to the ministry's further recommendation with respect to the first schedule. We're making 2 recommendations for the committee's consideration. One, that general qualifications and expertise be required for appointment of the Information Commissioner. And the second recommendation is that we add another ground of termination, that being a termination for cause.
Sorry, can I comment? I must confess, I didn't see this one about vacating at the age of 65. What's the rationale for that? I know that's the normal retirement age, but you have so many individuals who are competent, qualified, experienced, who could possibly serve beyond that time. And so I just wonder why we would impose an age deadline. Huh? Yeah, I mean, it just seems restrictive, quite frankly. And I don't think we should impose that. I do agree with the 2-term limit, but I don't think we should say simply because you reach 65 and you may be competent and doing your job well that you should leave the post because of that.
Yes, and you have judges that go up to 75. Is that so? Yes. Judges goes up to 75. Go up to 75, I think. Yeah.
So we're agreeing on the term limits to 2 terms, but no age limitation. Because you could serve starting at the age of 65.
You know much people in Parliament would have to go home? No, but seriously, I just don't think we should restrict it. Leave the 2-term, which I think is fine, but I don't think we should have an age. Obviously, if someone is not performing or has health issues, then that's a different matter. But I don't think we should just put an age there which rules out. A lot of people are at the peak of their professions in that age range.
Understood. I just want to point out though, so when you get to the pensions and gratuities, it links back to the same age, 65. So I'm just saying whatever, I don't know if it's as simple as, I'd have to think about it, because right now if you go to page 91 of the bill.
But wouldn't this person be kind of on a contract for...
No, this has a pension and gratuity regime here. So if you go to It says appendix to first schedule, and it talks about retirement, and you can retire on or after the age of 65 years. I'm saying there is a scheme that would now have to consider if you're going to change this whole thing about if you're not retiring at this particular age, then this pension scheme would have to be reconsidered.
Yes, but remember that if you are going to be limiting the term that the person can be appointed for, then with that limitation, I don't think it will impact the whole issue of the gratuity and so on and pension, because once you start to put a limit in it, then it definitely will impact that, because you have to serve some amount of time to be eligible for those.
And
Right.
that is there as well, that you have to have a minimum of 10 years service.
Right.
It does have that, but the first part is that you retire in pensionable circumstances if the person A retires on or after attaining the age of 65 years. So all I'm saying is if you're going to make a change on page 88, you have to consider how that impacts this pension scheme.
Yes.
I can check, but I know even with commissions of parliament, it's still usually, I will check for sure, but I'm pretty sure there is also, in relation to the pension aspect, that there is an age that is put in. So let me check, and so I think this perhaps is following that scheme. I'm not saying you have to be wedded to the scheme, but then you'll have to be careful when you make one change. You'll have to look to see how you reorganize what you have elsewhere, especially because there's also a reference to the Pensions Public Service Act. I'm pretty sure I just saw that.
Yeah, but what about?
Well, pensions, it really should say Pensions Public Service Act.
What is for my information, what's the term? Is it 5 years or 7? The term is 5? Is a 5-year term?
Yeah, but most of these persons, this kind of employment would be contractual arrangement. So I don't know how that would impact the whole issue of the pension arrangements.
Yeah, I would think the person would be treated in the way of a fixed term contract for 5 years, which would be, no? Or maybe they would be eligible for a gratuity or something.
Yeah.
Or they are treated as a typical civil servant
I don't think
in this case,
I
yeah?
don't think so. I don't think it would. Yeah.
I wondered, Chairman, through Soljan, can you just remind me the term public office under the Constitution? What does it mean?
No, it's not. The Constitution is only referencing civil service and civil servants. When we talk about the wider public service generally, that's not what is contemplated in the Constitution, because you didn't have creatures like executive agency and all these stat bodies. They came up later on. So you'll see, like in the Public Bodies Management and Accountability Act, they have their own definition for what they consider a public body. And in fact, different acts define public body in different ways. And in fact, we have been trying to ensure some amount of consistency throughout. But the general concept of the wider public service is not what is contemplated in the Constitution.
Right, and I ask you that because if it is that the commissioner, the office of the commissioner is not deemed a public office per the Constitution, then, and you can guide me here, then I wondered how relevant would be the 65 years retirement that
This is why I said you don't have to be wedded to it, but I was just looking for a precedent. Sometimes we do sort of follow certain
Children's
precedents,
advocate.
and that's why I wanted to make sure that I want to check something, and then I will.
And while they're looking at that, I wondered, and Miss Murray, maybe you can help me. I wondered why at paragraph 3, sorry, paragraph 4B, why is it that the commissioner has to vacate office after serving 10 years? Is there a reason? What was the thinking? And what's the magic of 10 years, which equal to 2 terms?
I think it was to certainly avoid a situation where you have one person that was at least a policy thinking, that you have one person sitting for an extended period of time.
Okay, so I've seen in the Integrity Commission Act, the 6th schedule, so a person retires in pensionable circumstances. This is an integrity commissioner. A person retires, this would be a commissioner, retires in no, sorry, this is the director. You want to know about the commissioners, because this is the director. But in terms of the director, it says you can retire on or after the expiration of 5 years from the date of appointment or by reason of ill health. A year, an age isn't used to say that that is how you retire in pensionable circumstances. It's not an age.
Any further updates?
Sorry, I know I'm a legal advisor, but policy intersects with legal issues. I'm just asking about the 2-year term limit, which is 10 years. Bear in mind, even with boards now, we are recognizing that it is very hard to attract talent and to keep talent. I'm just putting it that way. It's very hard to attract the kind of persons you would want. And remember, this kind of post, it may not be very easy to recruit. 10 years is a pretty short time. And I'm just saying that perhaps you would want to reconsider, because your pool may not be that big. And
Reconsider the 2 terms?
I'm saying reconsider the 10
The 2
years.
terms? No. We have a tendency in Jamaica to just concentrate knowledge in one person, and then over the years, decades, it's the same person. Always go to that person for information. Yeah, it's like.
I'm sorry, but when you're recruiting, it doesn't mean you have to go back with the person. When a term ends, there's nothing to say you have to re-employ or re-engage that person. But I'm saying the way you have done it now, there is no possibility for you to be able to re-engage if you want. So when you put in a limit in a law, you're going to be restricted. If you say that the person can be re-engaged, it's not an automatic re-engagement. It's not an automatic process. I'm just putting it out there.
Is it that you're saying if I'm going to take up the post knowing that it's only going to be 10 years, then we might not have persons wanting to take up the post?
Well, the first thing is it's not 10 years. It's 5 years. It's 5 years. It's 5 years, and you with a possibility that you could get another term. But the point is, it's a 5-year term. It's not a 10-year term. The only reason I called it a 10-year term is because you have no restricted it to say that the person now could never go beyond 10 years. And I understand there's a concept, just as how there is a proposal to have, for instance, fixed term limits for, say, prime ministers and all of that. I understand the concept, but I was just saying to just consider it again. But it appears that the committee is agreed, so.
All right, committee members. That's it. Ms. Murray, are you complete? All right, I put
Minister,
Schedule 1
Minister,
to the committees. Yes.
if I may, in at least partial support of the Solicitor General, I think part of the issue that also the committee should be aware of is that the nature of the Information Commission is a very specialized, a highly specialized area, which we have not really had in Jamaica before. And the concern, I think, that the SG has pointed out of having somebody who is competent in that post is something that the committee should also bear in mind in relation to this. Additionally, it might be useful to reflect on that paragraph 1 of the first schedule, that the commissioner is appointed on the instrument of the broadsea by the Governor General after consultation with the Prime Minister and the leader of the opposition. So it's not a simple rollover in that post. Perhaps the committee may wish to consider.
And I believe that even after considering all that, we're still going to say 2 terms. Yeah. All right. All right.
Chairman, before we move to the second schedule, because I think we're putting the first schedule to us, I would like to look at the appendix to the first schedule, and perhaps Ms. Aldred, you could again provide some guidance, because when one looks at the appendix, it speaks to, in fact, it deals only with pensions and gratuities. And I don't know if I missed that part of the discussion due to my lateness, but it presumes, I think, that the office of the commissioner would be a pensionable office. What I'm not seeing, though, is, and I don't know if it needs to be in here or if it is captured in the Pension Act, in a situation where an individual is seconded from a government job or a private sector that has a pension, I wondered whether there's any scope for that pension, the person is not yet vested, if there's any scope for there to be a transfer in this new position.
Marlene, while you contemplate it, what I would add in terms of the position, similar to what I know existed with the former contractor general, is that it should be pensionable at the end of a term. And the reason for this, you want the person to have the security and independence to make decisions in the best interest of the country without having to worry necessarily about what they will do next, which is why those positions are pensionable after 1 term. And I think that should be the case here, because you are making critical decisions which would affect large corporations. You're in a relatively small society where there are a lot of interconnected persons, and it can affect your ability to do something after you leave that post.
Member, in that same appendix, I think clause 4, Ms. Murray, clause 4 speaks to what you're just saying. Page 92. Look at special provision where a commissioner retires before attaining age 65.
Can I also ask what was the rationale for the 5-year term versus, for example, a 7-year term? Meaning you don't want, you deliberately don't want it to coincide with an electoral life cycle? Absolutely, you don't want it for reasons of independence. And so you would want it to overlap or not coincide with an electoral life cycle.
I would certainly agree with that, Minister, that we look at a 7-year term instead of a 5-year for obvious reasons. But in light of the issue raised before by Member Robinson, I don't believe it is addressed at page 92, because page 92, and I'm going to allow myself to be guided by the technocrats. But my reading of paragraph 4 on page 92 is that it is subject to paragraph 2, subsection 3(4). So you have to serve a minimum of 10 years, or you're 65 years old, or you retire because of ill health. And this does not deal with where you have not served for less than 10 years and you retire or you leave for a reason that is not related to health.
I'm not sure I can answer.
What Member Robinson, sorry. what Member Robinson was saying, as I understand, is that the pension, that someone should become pensionable on serving of a term and not necessarily 10 years. Yes?
That's what
And I understand the chairman to saying that that issue is addressed at paragraph 4, and I'm saying that my reading of it is that it does not address that issue at all.
No, that's a reduced pension. No, so the pensionable circumstances are in paragraph 2. Yes. And it's
So
saying
the first
10 years.
issue at paragraph 2 is that paragraph 2B should be amended to say has served a minimum of, has served at least one term. That's a minimum of one term. And there's a secondary proposal that the term should be 7 years and not 5 years. In other words, there's a mischief that I believe he's trying to treat with by extending the period for retirement to 10 years.
And that proposal, in terms of being in pensionable circumstances after serving one term, is consistent with the laws that establish commissions of parliament generally. So that is a construct that is understood. In terms of the earlier issue, which I understand to mean more linking of service, that if you were, yes, that if you were working elsewhere, but this does not allow for any linking. And in fact, there is a provision that is usually in acts, because remember now the office, whatever it's called, it's a statutory body, it's a body corporate. There, in acts that establish body corporates, you will have, there is usually a provision that allows for the Governor General to be able to authorize civil servant to leave the civil servant service and go into that position. And that allows for linking of service. That provision, I don't see it for the commissioner.
Right, and that's my question, because I did not see it myself and I wondered if I overlooked it. And the second part was whether or not we should have such a provision, or is it covered in the Pensions Act?
And you may have an issue having that kind of provision, because there is a provision on page 88 that talks about, it's different. That the office of commissioner becomes vacant if the commissioner is appointed to an office of emolument in a public service. So so I think you would have an issue trying to have a linking of service. The scheme of this act is not allowing for that kind of link. And I suspect there may be a reason around it. I suspect they want to have a separation. You don't want, I don't know. Let me not speculate. But it doesn't it doesn't allow for that now. The Pensions Public Service Act wouldn't really take that into account because it wouldn't allow, this is the act that would have to allow for the linking. And that provision is not here.
Miss Murray and Miss Francis, because I can't remember the Mrs. Miss Francis, whether that is something that the ministry would consider.
Back to the other point though, this really, the provision in the bill looks very, very, hold on a second, it looks very, very similar to what's in the Child Care and Protection Act with the age of 65 years. So what was in integrity, there were some changes. All right, so you had what, 8 commissions of parliament? And they all followed the same. It was almost like a precedent. They were not similar, they were the same. And then Integrity Commission, there are some differences in integrity. So you notice I said, for instance, in the Integrity Commission Act, there is no age of retirement. Well, not for the director or the executive director. But in child care and protection, for instance, there is an age and it's 65. There is an age, but it's the same basically as what is here. So I think maybe this bill was also modeled off the general formula of commissions of parliament. I also don't see anything here that allows for, say, any linking of service or allowing for, say, portability of pension. And I think the whole concept was that the child care and protection. I don't see, not for, you see, you may have it for staff, but not for the top person, right? Sorry, and if we had just looked at page 87 of the bill, you're disqualified for appointment if you're the holder of a public office within the meaning of section 2. Disqualified for appointment. So that is why you wouldn't have seen that page 87 of the bill, the disqualifying criteria, disqualifying, disqualification.
Is this, no, the person is a current or former? So you would rule, huh? No, so if you had, right.
The reason you don't have that provision that allows the Governor General to
so
appoint
you could resign
someone,
and
you'd
then
have
do
to
it.
resign and do it.
Oh, I just thought you were going to discriminate against people who sit in this house.
No, it just means you'd have to resign, whereas there are laws that allow for, say, a civil servant to be able to take that position without having to resign. That provision that we're looking for, that's not there. It wouldn't be there because this is saying you cannot be the holder of the office. So you can't be seconded. You can't go and leave.
I'm so happy you pointed that out because I do not support it. I cannot support it. I cannot understand the reason behind it. You have a public servant, you have a civil servant who is qualified to be the commissioner. And you're saying to me that the civil servant has to resign that position to take. No, I don't, because there are other things that one would have to consider. For example, I know a real life situation of a person who was not yet vested, but was very close to being vested, but another opportunity arose within the wider government service. And he was able to take up the secondment and to transfer his pension because he possessed the qualifications and the expertise that the other office required. Are you saying that in this bill, a person in that position would have to resign that office to take up the position of commissioner? And I don't agree. I cannot see the rationale behind it. I don't agree. And where did this come from?
Remember, this isn't unusual though, because this isn't unusual within the public sector either, because you have a situation where persons are leaving, for example, from a ministry within the central government to an agency or a public body, a statutory body, and are required to resign. There is no secondment that happens. No.
Does it mean that we should continue with that provision here?
Let me ask, sorry, on the clause 2C, how you define a holder of public office within the meaning of section 2 of the Constitution? So that's the same point. That's the same civil servant.
It's a civil servant.
Okay.
So okay, I put to committee members.
No, hold on. Sorry. There's a I had raised this very early in the in one of our initial sittings. Clause 2E. A person who has a financial or other interest in any enterprise or activity which is likely to affect the discharge of the person's function as commissioner. Now, let's say many of us have shareholdings in companies that would be the subject of the work of the information commissioner. No, I have plenty. But why should that disqualify you? I mean, I could understand if you had a majority ownership, but there's nothing here which speaks to the level of ownership. And with so many entities now going public and many people choose to invest in stocks, it just seems the interpretation is so vague that you could disqualify a lot of people using this clause. Yeah.
Sorry, and that is applying the last part to say likely to affect the discharge of the functions, because I think that was trying to help to guide how it would be applied.
But the problem with it, as you know, that is a subject of interpretation. So if I have 5%, 1%, 0.1, who determines whether that is likely to affect how I discharge it? Suppose that 5% represents 99% of my portfolio holdings that I personally have. Does that affect my ability to discharge my responsibilities? I'm just saying it is very vague and open to interpretation and could be used in a way that could rule out many qualified people.
Okay, so committee members, we have some decisions in the first schedule, paragraph 2E. Should we insert that would have to be a majority financial or other interest in the enterprise? Any comments from the technical team?
Chair, that's assuming that the interest is a shareholding. It might be some other sort of interest which might not be quantifiable that way. So that has to be considered as well.
Is there any guidance we can get from either what obtains at BOJ or Financial Services Commission, where individual may have to either put something in trust, declare it, something of that sort, but as I said, leaving it as is just too wide an interpretation.
All right, so members, can we, if there's no other comment from the technical team? Sure, go ahead.
Forgive me, But I am not seeing where it provides that the term should be 5 years. It's not stated.
Where?
Two? Right. Two, one. Two paragraph, subparagraph one. And it's a term not exceeding, so it could be less. And so, I mean, in even, so that in the context, yeah, but in the context of the discussion that we've been having about whether you extend it to 7 or not, it's still a maximum that you're setting, so it could be actually 2 or 3. Because it doesn't say 4 or 5 years, it says not exceeding 5.
All right, there are 3 items in the first schedule and the appendix to the first schedule to be decided. One would be the term, the tenure of office, changing that from 5 years to 7 years. I put that to the committee, 7 years. Then you have the other issue dealing with attaining the age of 65 to be able to get a pension. That's going to be left that way. If you're the pensionable age, 65. All right, I put that to committee members as the age at which you become pensionable. And then the other...
Madam Chair, I think there's a proposal not a proposal. There was a reading that Ms. Aldred had from the Integrity Commissioner, and it finds favor with me. I don't know if you could just remind us of the provision, please.
I think it's similar to this. So. For the purposes of this paragraph, a person retires in pensionable circumstances if he retires A, on or after the expiration of 5 years from the date of his appointment to the office of director or the executive director, or B, by reason of ill health prior to such expiration. So there's no age. This is the Integrity Commission and in relation to the director or the executive director.
So members, are we accepting the wording from the Integrity Commission Act? Right.
Chair, okay. A suggestion that we would have would be in relation to the pensionable circumstance, in relation to the pension, we could try an option in this way, that we allow the term to be a 7-year term, and then what we could indicate is that the person becomes pensionable. I'm now at page 91 looking at paragraph 2, subparagraph 3. So rather than have a minimum of 10 years, you would now link it to a single term. That's one. But because it says not exceeding 7 years in principle, you could have given an appointment for 3 years, 5 years, 6 years. So what we could do is look at paragraph 4, which allows you to be able to retire before you attain a particular age or special circumstances, so that if it is that your term is less than 7, you would have that deferred or lessened pension based on paragraph 4. So the member Robinson would have indicated that one of the things that pension does is to give you security while you're in the position. And what you'd want to consider is that if you have a full term of 7 years, you get your pension. But if your term is less than 5 years, you still have some pension to get, albeit a deferred sum, not the full 7-year period. So you still have that security that you're concerned about no matter what. So in other words, you're going to end up with something. So you are not looking at that. So that could be a middle ground to resolve that issue.
So what would change,
Yeah.
Katie, and what would change then? This minimum of 10 years service, is that what would change?
The minimum of 10 years service, yeah, that would have to change. And the age of 65 would change.
But let me ask, is
Yes,
the
14.
contemplation that having served the full term, you are, because I think in the other commissions of the parliament, when you become pensionable, the pension is pretty much the equivalent of what the salary. So this would be the same principle here. But obviously, if you are less than the 7 years, then there's.
No, that's fine. Yeah. Okay. So, Chair, it would be retires after a term, and a term would be not exceeding 7 years. But we'd have to be careful. Sorry.
Mrs. Newton, would we then delete paragraph 2 subsection 4A that speaks to the age of 65 on page 88?
Modification of office.
Mrs. Newton, I'm wondering, just listening to the discussion, if we were to delete subparagraph 4, subsection 4, page 88, would it do any mischief to what we're trying to accomplish? Because the issue of the 7 years will be dealt with both in the appendix and at paragraph 2. Or, I don't know, is that a provision that needs to be there?
Dealing with the when the office ends, the occupation of the office ends, and then the one on 90 is actually dealing with the pensioner situation. The two are linked, but it's really two separate provisions. So I don't think deleting 4 would necessarily. I don't think you can delete 4.
If we're agreeing then, and you can guide us as how to deal with it, because if we're agreeing that we want to get rid of the age limit at 65, then we'd have to delete that. And my reading, again, I stand to be guided, is that after 7 years, you can be renewed. But if you can be renewed, then why would the office becomes vacated? Or is that how it is phrased normally? Or would office become vacant? I'm sorry. Or is that how you phrase it normally, notwithstanding the option to renew or reappoint?
My understanding of the changes based on the discussion so far was that the provision on page 87, that's paragraph 2 of the first schedule, the 5 years would be changed to 7 years. Then on page 88, so paragraph 4, it would now read that the commissioner shall in any case vacate the office on completing 14 years of service as commissioner. Well, in that case, it's a case that you don't want 2 terms, then you just want a single term. Because I thought that in 2 we were still keeping the provision that the person could be eligible for reappointment on expiration. So it would be 14 years. And then when you go now to the appendix on page 91, paragraph 2, so paragraph 3, it would then read that the person retires in pensional circumstances if the person A retires on completing 1 term of service as commissioner, or by reason of ill health prior to such attainment, or has a minimum of 7 years service.
We're clear. You don't like the word crystal? We're very clear. Just one question. So we would then delete A and just keep B. Madam Chair, I am satisfied. I am, and I'm so sorry to have detained everyone.
So, committee members, it seems we have agreement on 2 of the 3 suggested amendments. So we're agreed that paragraph 2.1, that the term should not exceed 7 years. That should be changed from 5 to 7. And then in the appendix, I need to know. Yeah.
Page 88 should be changed to 14 years.
Page 88, 2.4b, that should be changed to 14 years, right? And in the appendix to the first schedule, amendments to say that a person retires in pensionable circumstance if the person retires on completing 1 term by reason of ill health and so on, and has a minimum of 7 years. Agreed. So the only other likely amendment would be in 2E in terms of guidance regarding majority financial or other interests. Right, Ms. Grant? Okay. So what do we do for that?
Chair, there were 2 other. There were 2 other recommendations we had made in relation to the first schedule. The inclusion of general qualifications or expertise for the appointment of the commissioner, and adding another ground in relation to termination, that being termination for cause. To direct the members. So the subparagraph that would be affected is 2, so, paragraph 2, subparagraph 6, to add termination for cause. And then the provision in relation to the general qualification would be a new provision.
So I think the team is just contemplating 2E, paragraph 2E, in terms of majority, financial, or other interests.
Ms. Marie, based on the proposal of the ministry in terms of the qualifications, expertise, I wondered if you had something that you could share with us to look at.
But it wouldn't be dissimilar from, well, a recommendation I would have shared maybe 2 meetings ago in terms of some of the qualifications that the DPO, the Data Protection Officer, would need, i.e. Skill sets in data protection or related skill sets, ICT or along those lines, law or something of the sort. So those kinds of options. We would work with the CPC to.
And then just a comment, Chair, that if you're going to be including a provision dealing with termination for cause, you have to include a provision, the procedure for the termination for cause. Remember that this person is going to be appointed by the Governor General. Usually you'll have to, these types of positions, you have a procedure, like a tribunal, etc. But there are several precedents for that. You can use a precedent from a Commission of Parliament or something in the Constitution.
Chair and members, I think the concern that was being raised in terms of the majority interest or adding language majority is that while it might be applicable to financial interest, it couldn't apply to the language that follows after, which is other interest. And we think while it is vague, we take the point from member Robinson, but the linking words of the person's function and how that would affect the person's function is an assessment that would have to be made, and we believe that it could be made in the circumstances. Yes, it will vary from person to person, but it is an assessment that can be made because what you would be doing essentially is determining based on what is presented whether or not this amounts to a possible conflict of interest in a way that would be substantial.
All right. I put the first schedule to committee members with the amendments in clause 2.1 to change the term from 5 years to 7 years. An amendment in clause 2.3b to change from 10 years to 14 years. And amendment in the pensions and in the appendix to the first schedule, paragraph 3, that speaks to retiring on completing 1 term, and 3b, that should be a minimum of 7 years, and to include a new provision that speaks to the general qualifications of the commissioner, and to amend 2.6 to add the termination for cause plus the procedures for termination. I put the first schedule and the appendix to the first schedule to the committee members.
Chair, just before you do that, could you just draw your attention to page 92 onto to paragraph 4 of the appendix? There's also going to have to be a consequential amendment to this because this reduced pension is linked to age, and so it will now have to be linked back to the completion of a term or any shorter period. So CPC will have to go through and make the adjustments accordingly because this one is currently linked to an age.
And that would be for what?
That's on page 92, paragraph 4 of the appendix.
Okay.
Right, so that has to be fixed. Thank you, Chair.
All right, thank you. So I put the first schedule and the appendix to the first schedule with all the amendments. So moved. We accept the first schedule and the appendix to the first schedule. We'll move on to the second schedule, miscellaneous exemptions.
One comment here from the Hart Mirad Fatah. The recommendation from that firm was that an exemption be provided for immigration policy, as the processing of personal data without the consent of the data subject will more often than not be required in those instances. The addition of separate exemption would eliminate the need for taking an unnecessarily liberal reading of national security, is their comment. We would have looked at other pieces of legislation and found none that made a specific exemption for immigration purposes, and we believe that national security related issues are sufficiently wide to treat with immigration issues, and we wouldn't therefore recommend any further amendment to include a reference to immigration policy.
So
Is it just the examination of the legislation? Is there anything in some form or other judicial precedent that guides the definition of this national security term? Meaning, you said that you looked on the legislation and national security is sufficient to encapsulate immigration, right? That's what you're saying? Am I wrong?
So our contention is that we haven't seen in any piece of legislation any specific reference, anyone putting an exemption in for that.
So see if you can follow me and carry me through. What the recommendation rests on the I guess it would be suggestion that it would be beneficial to distinguish immigration, right? That is what Hart, Muirhead, and Fata is saying. You are saying there's no need to distinguish immigration because any issues in terms of exemption for immigration would fall under national security exemption. Is that what we're saying?
Well, any issues that would require exemption, because we're saying that generally this is a right for the protection of data subjects' privacy in relation to their personal data. And if we're going to be making exemptions in relation to it, as we have in this bill, it is along certain lines. And those are in relation to national security and law enforcement related issues, tax, and so on. So we wouldn't if you're going to treat with immigration issues, then we're saying it has to be within the context of the broader exemption of national security, because we're not adding further exemptions to the legislation that are not of the nature and kind that we've already dealt with in here, i.e. tax, law enforcement type matters, and national security type matters. Otherwise, the data subject must be engaged in the same way. If we think about immigration policy broadly, someone could be applying for citizenship, for example, and then it's a matter of me releasing my data to you. If a security issue arises in relation to my application, it is that a security issue, and you will treat with that under the exemptions that are here. But we can't think of, and in light of the scheme of the legislation where the exemptions are limited to functions that are being performed and required by legislation or national security issues and or tax related issues, we don't want to add, and we wouldn't recommend adding any further exemption, and certainly not as broad as immigration policy. I mean, yeah.
I guess one of the difficulties is that you don't have much practical, there's not much, so you just have to go with what you think is best until we actually get into the whole practice of the issue. All right.
All right. I put the second schedule to members. If there are no...
I may have missed. There's already an exemption for the JCF, right? And all... Just broadly national security, okay.
All right, I put again the second schedule to the members. There are no objections. We move to accept the second schedule and move on to the fourth schedule.
There are no comments, members, on the fourth schedule.
Thanks. I put the fourth schedule to the members. No objections. We accept the fourth schedule. Do we now put the memorandum of objections and reasons? Or we go back to the matters arising? Yeah, we did the fifth already. We did the third and the fifth already. Yeah. If you look at the handout called summary sheet of the decisions made by the committee, you will see at the back of that the amendments to the third and the fifth schedule. All right, so do we now go to the memorandum of objects and reasons, or we go back to deferred items, all the items arising from the minutes?
Skill set for the tribunal for the fifth schedule. Did you present it to us last week when I was absent?
I don't even understand that this is about to mix it up with the, you know, when we were requesting information about national.
There was just one single comment on the memorandum of objects from Lawyers Christian Fellowship. They noted that the exemptions to data protection standards for the purposes of law enforcement, tax, and statutory functions seem to be at odds and disconnected from the purposes set out in the objects and reasons. We just want to point out that the objects and reasons provides the general policy motivation for the promulgation of the legislation, and in fact will eventually fall away.
All right, I put the memorandum of objects and reasons. The committee members, there are no objections. We move on. We move back to matters arising from the minutes and take all the deferred items. All right, Ms. Murray.
Okay, members, taking you back, all the way back to clause 2, accessible records. So what we'll be doing, and we would have presented additional research in relation to the questions that would have arisen at various points. And so the first one we want to take the members back to is the accessible record. Members will recall that consideration was given to this, but it was deferred for further examination. So we remind members that the minister recommended that the definition of accessible record be deleted from clause 2. We point out that the term is used in the definition of data in clause 2 at D, and used in conjunction with clause 39, which members will recall the committee has agreed to move to the transitional provision. In light of that, there is no further need to define the term in the bill. The amendments which will be made to the transitional clause will provide for the 2 years for exemption for manual records of any type held by data controllers in the public and private sector. If the recommendation is accepted to delete the term accessible record, we point out as well that we'll also have to delete the reference to educational record, which is only used in clause 2 in the definition of accessible record. We note that we will still have to retain the definition of health record because health record is used in clause 66. So in summary, with respect to accessible record, the recommendation is that that definition be deleted because of how we're going to, well, the committee's agreement with the treatment of clause 39 to which it is related, and then the consequential removal of educational record, but noting that we will retain health record because that continues to be pertinent and relates to clause 66.
Chair, I'm a little hesitant about the recommendation to delete educational record. We might still need it based on the reformulation that we would have to do to the clause 39, which is going to be moved to the transitional provision. Because we are going to, in keeping with recommendation, delete the definition of data and accessible record. But as far as the definition of educational record was concerned, it might have to be repeated because the only reason it wasn't mentioned more in the bill itself was because it was dealt with in the way it was defined in accessible record. But because we're deleting that now, we might have to make explicit reference to the educational record in the reformulated provision. So I would prefer if we not refer expressly to deleting that definition.
Chair and committee members, the tracked changes to the bill based on all the recommendations that are made here will have to be taken back to the committee so that you can actually see what it looks like. So I believe this issue about what is deleted and what is not and what is consequential in relation to recommendations and that has been agreed by the committee will come out in the wash, and we'll see that once the track bill is back, and we can go through that a little bit more clinically. But so we'll defer to the CPC in relation to how we use the term because but we'll guide the committee through that once we get back here in terms of what we did with it based on the drafting. At this point, we're deleting accessible, not educational record, and right.
So we have to re-put. Okay. So I put to the committee the deletion of the term accessible record, which means a health record or an educational record, but bear in mind the objection of CPC as to the fact that they would not want to delete educational record, but may need to make explicit reference to it relative to other clauses. So I put that amendment for clause 2.1. There are no objections. We accept clause 2.1, deleting accessible record but keeping educational record. So approved.
Still in clause 2, the ministry was asked to revert to the committee in relation to the definition of behavioral characteristics. The committee will recall that we recommended that the definition for biometric data be amended to read as follows. Biometric data means any information relating to the physical, physiological, or behavioral characteristics. And I think that's where we had a pause in terms of the need to go back and research and provide further information. So the recommendation was made on the basis that there are two types of information that would be addressed in biometric data. Information pertaining to bodily characteristics such as facial image, fingerprints, iris scans, etc. And then the other type of information being behavioral information pertaining to someone's habits, actions, or personality, which could be, for example, how they walk, how they do their tick, or their gait, or something of the sort. The ministry appreciates that the term behavioral characteristic is potentially broad, as it has no connection to bodily information typically thought of as biometric data. However, as biometric technology is relatively nascent and we will continue to evolve, we think it's considered necessary to encompass data that may arise through the development of future technology. And while it is that we're sure that the bill will be, or the act once promulgated will be under review, we want to make it as future-proof as possible. With respect to the issue of the separation of the definition of genetic data from biometric data, it is recommended that genetic data remain separate from that of biometric, as genetics is concerned with the study of genes, which are a sequence of nucleotides found in DNA and RNA. We note, for example, what obtains in the GDPR, where genetic data is defined as relating to the inherited or acquired genetic characteristics of a natural person, which results from the analysis of biological samples of DNA and RNA. And for that reason, we would recommend to the committee that we keep genetic data separate from biometric data, and indicate as well that while we appreciate that the term behavioral characteristics would include things that are not necessarily related to bodily information, it might still prove useful to retain it in light of just how technology is evolving.
Okay, so I put to the committee members the recommendation of the ministry to...
Chairman, I think, and it wasn't in the definition clause that the issue of the term behavioral characteristic came up. And I think, if my memory serves me correctly, the concern of the members was really, how do you define behavioral characteristic? I am not sure, based on the recommendation here, that we have dealt with it, or it's not settled in my mind, what exactly is behavioral characteristic. So is it that, I'm not even sure what is it you're asking us to approve. Save and accept, I understand the difference between the separation from genetic data.
So initially what we had asked the committee for, if we go to the page 2 of this matrix, was that we amend the definition currently in the legislation of biometric data to mean any information relating to physical, physiological, or behavioral characteristics of an individual, and it would have gone on. So the question was really around what is behavioral characteristics, and we are saying that behavioral characteristics is really around habits and actions, and or which could include, for example, how you walk, how your gait, whether you have a tick, whether you knit your brows, or you have a constant knit. I mean, things like that. And what we're saying is that while we understand the concerns around the use of the term behavioral characteristics, we believe that the technology is evolving in such a way that when it captures something, and we don't know where it's going, you might want to leave something sufficiently wide to capture everything as opposed to leaving it out and coming back. So we see this as a way of kind of future-proofing the legislation. But essentially, that's what our research showed, is that how behavioral characteristics are really around information pertaining to habits and actions and personality type things that are visual, I suppose.
So you're asking us to...
It would fall within the definition of biometric data and would be treated as sensitive data, because it could be used to identify you.
It will become increasingly sensitive data, because what I said a while ago, jokingly but it's serious, is if you even take the websites that you visit, right, as habitual, right, Jamaica Observer, Jamaica Gleaner, other websites, right? And these are things which could become, very sensitive information. Maybe not now, not for us who are here, but I'm saying in the future, for future legislators.
And I take that, and I understand the reason why I'd want to keep it. But the only concern I have, Ms. Murray, is perhaps, and CPC can provide some guidance, perhaps we need to have a definition of behavioral characteristic, because using the term in here by itself leads for a lot of interpretation. And notwithstanding the conversation that is taking place here, and we are part of the parliamentary record, we know that not all courts are prepared to accept Hansard. That's my only caution.
But the same could flow. Huh? The same could flow for physical, psychological.
No, but some things like...
Is your physical characteristic you, or is it how you dress?
It's so new to the whole data protection that you don't want to live in a gray area. When you go before site to tell her that they don't care what Hansard says.
What we're thinking is that in our research, it was difficult for us to pin down a definition for behavioral characteristics. So what they spoke to was, actions and habits and so on, general. But in the conversation with CPC just now, we're thinking we could use including to kind of guide what we're thinking about or what is being contemplated. Yes.
All right, so I put that amendment to members to include behavioral characteristics as information that forms part of biometric data and so needs to be protected. Additionally, we put to the members the recommendation that generic data is to be separated from biometric data. If there are no objections, we accept this amendment. Ms. Murray?
Following the summary sheet, the other issue the other matter that was deferred for further examination was the recommendation from the Ministry for the deletion of the term data. We believe that the committee was in general agreement with the recommendation. However, what was then recommended was that wherever data appears in the legislation, the word personal would have to be inserted. And I believe the CPC has already gone through and made those amendments, and the members will see that in the bill that returns. So I think we had satisfied ourselves that personal could be inserted before data and would not cause any kind of anomaly or issues. Yes. But with the right, and then inserting the word personal everywhere data stood by itself throughout the bill. Personal data.
So I put the amendment of data to be deleted and insert personal where the word data appears in wherever it appears in the bill. If there are no objections, we accept this amendment to clause 2, interpretation and objects. Approved. Ms. Murray.
Member Fraser Binns. So I believe this is still here because there was a request by the member for this to be to allow for further consideration of this, but so the issue really was around a recommendation that the health insurance companies be included in the definition of, well, it was on the health record, but really should, I think it should have been a recommendation that they be added to health professionals. I think it's the stakeholder who commented on this section made reference to the health records, but it really isn't the health records that it was applicable to. It's really the health definition of health professionals. So the recommendation from the stakeholder was that insurance companies should be added to the list of health professionals. And the ministry would have indicated that it is not in support of that recommendation. Just the point being here, member, that's okay, I'll just further clarity. The point being here that health professionals in the legislation can process data without the data subject's consent if they're doing it for medical purposes. Medical purposes is defined, and I'm sorry, just one moment. Medical purposes again, 24. So medical purposes is defined in clause 24, subclause 2, as including purposes of, and this is page 39 of the bill, as including the purposes of preventative medicine, medical diagnosis, medical research, provision of care and treatment, and the management of healthcare services. And we don't think that insurance companies fall within that definition in the first place of the person who, or yes, a person who should be able to process without consent for medical purposes. Right, and if they're included, it means that they would be able to process the subject's data without the data subject's consent. And And then we would have indicated as well that we really don't believe that they're offering services of a medical nature. I don't know.
What?
On my insistence, I was just indicating to Ms. Murray and team that I can't recall the reason why I would have wanted it, but based on the explanation she has given to me, then I'm in full agreement with the Ministry's position.
So I put clause 2 to committee members that a health professional. I know. That health record health professional can
The definition would remain the same,
can
Minister.
process data, health data, without the consent of the data subject, if they're doing so for medical purposes. So there's no change to the definition. Okay, I put the no change to the committee members. Approved.
Say health data. For the health professionals, in terms of their processing, does it specifically say?
The legislation defines health records. And the health professionals process sensitive data or personal data or sensitive personal data, but it does define health records in the context of the legislation. So sensitive data would be anything including your genetics, biometric, anything related to your medical or health, anything related to medical, physical, or yes, health.
Go ahead, Ms. Murray.
Okay, I believe committee that we've treated with members that we've treated with personal data. Right. There was one thing though, because we had deleted the recommended the deletion of the definition of data. There, we had indicated that one of the things that that particular definition did was to describe the processing or how data was processed, i.e. whether electronically, automatically, or manually. And we believe that that concept of how data is processed is still relevant, and so that should make its way into the definition of personal data. So we're just reminding the committee here that while a decision has been taken on personal data, that the words whether or not by automated means be inserted after the words information or data within the definition of personal data.
Data or the definition of process.
Yeah, because I think it's either the definition of personal data or the definition of processing. We'll defer to the CPC on this particular one. The CPC is indicating that language to this effect would have been included in the definition of processing.
All right, so I put the recommendation from the ministry. The ministry is recommending, no?
Members, this one wasn't before us. This is a consequential amendment in relation to schools, to the definition of the word school, rather. So the committee will recall that it agreed with the ministry's recommendation to delete clause 35, which made provision for the minister to exempt from the disclosure to data subject requirements information related to mental and physical health, school and social work. So because we're deleting that clause, then this amendment would also have to delete the definition of school, because that was the only place that it was referenced. So we just wanted to bring this particular amendment to the committee's attention. So this is a consequential amendment based on a decision that would have been taken in relation to clause 35.
So I put the consequential amendment for clause 2, and that the definition of schools, which is only used in clause 35, be deleted. And also I need to put the recommendation that the words whether or not by automated means be inserted after the words information or data.
No, Minister, we were pulling back from that definition based on the fact that CPC had indicated that it would be used in the word processing. So we're
oh, you're taking this back? Okay. All right, so what do I think?
Clause 17.
All right, no, we just want to put to the committee. No? Okay, that the words whether or not by automated means to be included in the definition of process. No objections, we accept. That's it. Okay, Ms. Murray.
So on clause 17, in relation to the requirement for data controllers to register, the committee would have requested that the ministry provide it with some information regarding the likely size of data controllers that will be placed on the register, and some budget projections in relation to the Office of the Information Commissioner. So what we have here and what we would have presented is information that would have gleaned from the Ministry of Industry, Commerce, Agriculture and Fisheries. We outline here how they define MSMEs in terms of macro, what is considered macro, what is considered small, and what is considered medium, noting that micro is less than 5 persons, small employees rather, small between 6 and 20, and medium between 21 and 50. And of course there is the indicator, that's a secondary indicator based on the policy, that is the micro, small and medium enterprise and entrepreneurship policy. But the primary indicator is in relation to their turnover, which is less than $15 million for micro, between 15 and 75 for small, and medium over 75 but less than 425. The policy inciting the data obtained from Tax Admin Jamaica notes that approximately 97.6% of all classified taxpayers for the financial year 15-16 were MSMEs, with 83% of those being or falling within the category of the micro sector. Mike have also indicated that there are approximately between 400,000 and 600,000 MSMEs. We also got data from the Companies Office, but we would have put the MICA figures there because an an MSME might not be actually registered either as a company or under the registration of business name. They could be a sole trader operating under their own name. But the data from the Companies Office reveals that there are about 64,735 registered companies, 151,000 business names, those registered with business under the Business Name Act, and about 1,000, almost 2,000 overseas companies. We're not sure how many of those have been deregistered or dissolved or removed, closed, or dissolved or removed, but those are the figures we would have received. Additionally, the data from the Department of Cooperatives and Friendly Societies indicate to us that there are approximately 100,000 of those cooperatives, and they're distinct from the companies and business names. With respect to the budget projection for the OIC, this is the consultant the ministry would have engaged or provided to us by support from our international partner. That report would have estimated a budget of about 1.7 billion Jamaican dollars. We think it's kind of high. And it's something that we certainly will be looking back at, but we put that forward as what those indicative figures look like. Notably, the consultant in its report recommended that the Office of the Information Commissioner focus in the first 3 years of its establishment on medium and large companies, and estimated an annual registration fee of about Jamaican $12,000. So that's just the, well, we present that to the committee for information.
So I put that. The definition, I put it to the committee that we use the definition of micro, small, and medium enterprises as defined in the, no suggestion. No, but we have to.
Members, the information was presented primarily to assist the committee in determining whether or not all data controllers should be required to register or not. And there would have been concerns from stakeholders about MSMEs having to register and the cost that might be attendant to that. So the information that we're bringing is just to assist the committee in determining whether or not everyone should be required, all data controllers should be required to register, and we would have given an indicative cost based on the report of the consultant of what that likely registration fee could be. But we wanted to also point out, you know, what would fall within what category if we were going to make a distinction in terms of certainly if it's going to be done by size or annual turnover, then we would certainly be guided by the policy, the MSME policy.
But if I remember correctly as well, there was a thinking that given that this is so new, that you'd want to establish at least the data for the companies, and given that there's an estimation that this might not cost any more than $12,000 for the year, which is $1,000 a month. You know, and I don't see why we should not collect that data in the first place. We can decide, the commissioner can decide later on based on the experience that they would not have to register small and medium size or micro and small entities, but first out of the gate, I think all entities should be required to be registered.
That is indeed a recommendation from the consultant, that the focus be first on the bigger players, and then you look a little bit, the commissioner would be able to look at the others. But all would be required to be registered, but the initial focus would be on ensuring that larger companies are on the register.
I do recall, Minister, that that was in fact the discussion, and the Ministry's position clearly has not changed in terms of who should be registered in the initial stages. But I think it was Member Robinson, myself, and perhaps Member Scott who wanted the additional information to guide us in determining whether or not it should be whole scale as a start, or whether we should start with the larger companies. Having looked at this information, I am, to be honest, Minister, when one looks at what presently obtains in terms of the small and the micro, which clearly forms the bulk of it, then I have to show some understanding to the position raised by Member Morgan then. And at this point, my position is that we could certainly open it to everyone, and that over time the commissioner would move, and quickly too, to only insist that the larger companies are the ones that provide the information. Because interestingly, what I noticed is that the combination of the micro and the small are actually quite extensive compared to the larger companies. And so it is for that reason why I would be minded to change my initial thought.
All right. So I believe we all agree that everyone should register at the beginning, and then the information commissioner, based on the experience, can then begin to decide who does not have a need to register.
The only thing I would add, though, Minister, is whether there could be a specific provision. I don't recall there being one. You can guide me. That empowers the commissioner to have that empowers the commissioner to filter. I'd want such a specific provision, and also whether a policy decision could be taken to ensure that the cost associated is not so much of a deterrent, but whether you could get some kind of benefit, something. I don't know how we can carve it out, but we have to bear that in mind as well in terms of the cost implication. But certainly, I would want to have an express provision that allows the commissioner over time to filter out.
Minister, members might recall that there was an amendment that we had made in relation to the requirement for data controllers to annually submit an impact assessment report, and language along the line, Member Fraser-Binns, that you're suggesting was actually, amendment was made in a similar way to that particular provision. So we're thinking that that could be accommodated here to empower the commissioner to be able to, at some stage, determine who should.
I still have a little challenge with that, though. In terms of how are we going to determine who really, especially in the small and micro enterprise, who really is a data controller? How are we going to determine those persons for registration?
Remember, right, the registration, you're going to define yourself, right, as collecting. You're selecting to be a collector of personal data. If you don't collect it, you don't have to register.
Yes, yes, but you are saying that all persons should register at first, and then
All the entities that define themselves as collecting personal data should register. Yeah.
should register. So what would be the purpose of the commissioner thereafter in terms of?
So the registration is an annual process.
Huh?
The registration is annual. So every year you have to come and keep yourself on a
but in terms of the payment of the fees and so.
and because you're required, once you're processing personal data, you're required to register, and you'll pay an annual fee so it's an annual registration. So the sentiment and the concern or recommendation is that what you would do is allow at some later stage, within the first maybe let's say 2 or 3 years, everyone that processes personal data would be required to register. But the amendment that is being proposed is to enable the Information Commissioner at some later stage to determine, based on guidelines, based on grounds, that these types of processors or data controllers don't need to register, but these do. Others would.
Yeah,
and that determination would be made by him, of course guided by his directives and his or her directives.
But if you collect from them in the first place for a registration, and then afterwards you say they are not.
No, well, it's not anticipated that it would be within the middle of a year. It would be at that point thereafter, so that data controller would no longer be required to annually register.
To annually register?
Which is the case.
Yeah, but what in terms of the fees that they would have paid already?
$12,000 for the year.
Yeah, I know, but what about? Well, that is the point I'm trying to make. That's the point I'm trying to make.
A requirement by law for you to do a particular thing at a particular time, and then the law says, no, I don't need you to do this anymore. So that $12,000 or so that data controller would have paid would have been passed and spent.
I see.
And not returned.
All right. So let us move on. There's nothing to change. Okay, Ms. Murray, you keep going.
Clause 20.
Sorry, Ms. Murray. Clause 17, then I put to committee members that all companies processing personal data would be required to register, in addition to doing their annual impact assessment. And in that process, the Information Commissioner can determine later on what companies would need to register and which ones would need not register. No? Okay. There's no change, though. Is there contemplation on this clause 17? Is there further contemplation, Ms. Murray?
Yes, Chair. I think CPC is bringing to our attention the fact that there is no currently, and I'm going to hand over to her.
recommendation was being discussed that the commissioner be given the power to exclude certain data processors based on size or whatever other criteria. But in the existing clause 15, there's already a provision for excluding, based on discussions that went on before, excluding certain types of processing or data processors, and that power was given to the minister by order subject to affirmative resolution. And it was qualified that it would have been processing which appears to the minister unlikely to prejudice the rights and freedoms of data subject. So if we're now contemplating giving that power to the commissioner, we'd have to reevaluate whether this exclusion, giving the power to the minister to make exclusions here in 15.2 would still need to apply.
We don't know what exists right now, and that's why we're saying that all companies that are processing personal data should at least register, so the information commissioner would have would know who exists. So no fee for the initial registration?
Yes. For the initial registration, I think there should be charged a fee, because then you will, after charging them the fee, then you go back and you say, okay, well, you never need to pay, or you don't need to pay. I don't think it looks tidy. So in the initial registration, everybody registered, then we make a determination now who falls into the category for paying fees and those who are outside.
Which clause? 15? 15. 14. 15? 15. Okay, so Member Witter is saying that for the initial registration, there should be no fee charge in that initial year. Yeah, and then after that yeah, okay. Okay, Ms. Murray.
So, Member Binz, you were out, and then you had raised this issue about the commissioner being enabled to determine who, right? But we are reminded by the CPC that in clause 15, that power now resides with the minister to determine the type of processing that would be excluded from registration. But we could amend to further amend 15.2 to require consultation with the commissioner, and of course that this be something that comes to Parliament for affirmative resolution if the members are minded.
So I put the amendments to clause 15 as stated by Ms. Murray. No dissent, we will accept clause 15. Ms. Murray.
And then Chair, you're putting 17 and there are no amendments being made to 17.
Okay, I put clause 17. No amendments to clause 17. If no objection, we accept clause 17.
Clause 20 was deferred as well. MSET is to return to the committee with appropriate drafting language to be used in the clause regarding data controllers who would not be required to have a DPO. So we would have set out in the additional research which we would have done before you at page 8 through to 10 or 12. What we found in our research was there are several those countries that required data controllers to appoint a data protection officer. There were several of them who made no exemption, so everyone was required to appoint a data protection officer. But for those that did not, those are outlined in the research findings. So of the 107 countries that we would have surveyed, we only found 6 in addition to the EU countries that specify the types of data controllers that were required to appoint a data protection officer. What we noticed was that some countries make the determination based on the number of employees. So for example, Croatia requires data controllers with over 20 employees to appoint a data protection officer, while North Macedonia requires data controllers with over 10 employees. Others prescribe the type of data controller that is required to appoint a data protection officer, and that is just by type, not by number of employees. So for example, in the EU, Israel, Uruguay, they require public authorities to appoint a data protection officer. And in Israel, they further required banks, insurance companies, or companies engaging in rating or evaluating credit. Some countries make the determination based on the type of activity that the data controller is engaged in. So for example, in the EU, they require data controllers engaged in regular and systematic monitoring of data subjects on a large scale and processing sensitive personal data and criminal convictions to appoint a DPO. In Israel, data controllers that possess 5 databases would have to appoint a DPO. And in Uruguay, they required private entities whose core activity is the processing of sensitive data or large amounts of data to appoint a DPO. In Brazil, we know that the commissioner is empowered to make rules outlining the entities that do not need to appoint a DPO. And the matters that they consider in Brazil include the nature and the size of the entity or the volume of the data processing operations. In Cyprus, the commissioner is empowered as well to publish a list of the entities required to appoint a DPO. However, unlike Brazil, no guidance is provided in the legislation as to the factors to be considered in making that determination. We note that North Macedonia adopts a different approach and simply indicates those entities that are not required to appoint. So they do a negative list, I suppose, to appoint a DPO. And so those entities that have fewer than 10 employees intend to process publicly available personal data, and those intending to process personal data of NGOs, for example, or NGOs that are established for political, philosophical, religious, or other or trade union purposes do not have to appoint a data protection. So in light of the research, the ministry recommends the adoption of possibly both a kind of negative and positive list if the committee is minded. What we we've outlined here is a positive list would require the following data controllers to appoint a DPO: public authorities, full stop. Right, so just once you're a public authority, by definition in the legislation, you'd have to appoint a DPO. Those that process sensitive personal data and criminal data related to criminal convictions, those that process data relating to a large number of data subjects also. And the committee could exclude from the requirement to appoint a DPO non-profit organizations that are established for political, philosophical, religious, or trade union purposes. And of course, they could exclude those that operate a public register, because the information is public already anyway.
So, quite a bit to digest, but Miss Marie, it's quite a bit to digest, but the final recommendation is that a combination of public and private. That's what you're recommending? No. I mean, a recommendation of positive and negative. You see, when I said it's a lot, positive and negative list. That's what you're recommending? Yeah. Okay, because I'm looking back at the definition of public authority. It's on. I'm looking at the definition of public authority on page 7. And the catch-all category at F. Any other body or organization which provides service of a public nature which are essential to the welfare of Jamaican society. I mean,
specified by the minister in a gazette.
Right. So, that's
so to the extent that there is no one identified as falling into this category, then.
So under this is where your charities will be excluded. Right, the negative list. Right, that's where your charities will be excluded.
Depending on the purpose.
Okay.
Is what we're suggesting here based on the research that we've done, depending on the purpose. So you could be a charity, but if you don't fall within a religious tree, an NGO.
Right. Yeah, that's true.
Right,
Charity has a specific meaning under the Act now, so let's go with NGO.
Right, so NGO. So if you don't fall within this, the purpose, then you would have to. A DPO, right. Sole traders, depending on what you're doing. So if you're processing sensitive personal data on criminal, or you might be a sole trader, but you're processing a large data relating to a large number of data subjects, and we know large is yes, but it's hard to put a number on large. We could, but I mean, then you would fall into that, notwithstanding the fact that you are a sole trader. That's the idea. Bearing in mind that this is around the appointment of that data protection officer that will act as a liaison between the data subject and the organization, and of course, the internal police, for want of a better word, to ensure that the data controller is operating within the remit of the legislation.
Amen. All right. So we I put to the committee that we accept the recommendation from the ministry or from the technical people to have a positive and a negative list as set out on page 11 of this additional research paper. En bloc? All right, Miss Murray. What else we have? What else we have? Hold on. What else? Ms. Murray, please continue.
Chair and members, with respect to clause 23, the committee had previously accepted a recommendation from the ministry that there should be an offense if one re-identifies anonymized data, or put another way, de-anonymizes anonymized data, and the ministry was to return to the committee with an appropriate fine and term of imprisonment. Our research indicated that there are some countries that really do not have this particular offense as a part of their data protection law. But for two countries that we found that did, that being the United Kingdom as well as the Isle of Man, in the UK, their particular approach was just to create an offense which was punishable via a fine, and that would have been determined on conviction, whether in summary conviction or indictment, the court will determine what the fine would be. So they just made it a fine and not something that was liable to conviction. No, they just said liable to a fine. That's just the way they had structured it. However, Isle of Man actually did a breakout. Isle of Man was a little bit more specific and had indicated that on summary conviction, the liability would be to a fine not exceeding what is equivalent of about 1.9 million Jamaican dollars, what they call a level 5 scale, which is £10,000, and also 6 months imprisonment, or on indictment, they left it at large because of the nature of how offences on indictment are treated, to a fine which the court will determine, or to imprisonment for a term not exceeding 2 years.
Any cases in your research that give you examples of the use of these kind of sections in the legislation?
We haven't seen that, but what we can share is that there has been some concern about the fact that there is a criminal offense for identifying anonymized data. In particular, in Australia, New Zealand, I believe there was an attempt, at least for the last 3 years, probably about 4 years, to try to introduce similar legislation which is an amendment to their privacy legislation, to allow for criminalization of re-identified anonymized data. And the concern really is that you are going to be criminalizing something that some persons do as a part of their natural, normal course of business. So for example, if you are in tech, you sometimes do testing, stress testing essentially, which requires you to see whether or not there is a fault within anonymized data, and you end up re-anonymizing the data. However, what we have seen is that in other legislation where they actually create this section, they do allow for a defense to say that you were actually doing some type of stress testing, or you were doing, it was for detection of crime or something, and I do provide for that. So we haven't really seen prosecutions under this based on what we've looked at, but what we do see that there's a lot of discussion about it, the fact that you are criminalizing this particular offense. However, we think it's important for this particular clause to still be included, hence why the committee would have accepted it. And at this stage, we would perhaps, our recommendation is that we don't go the route of a custodial sentence, but rather that we leave it at a fine, which is the approach that was taken in the UK.
All right. I put clause 23, the amendment to clause 23, that we leave this as a fine rather than as a custodial sentence. If there are no objections, we accept the amendment to clause 23. And
No ceiling in terms of the fine.
No, they didn't. They just said to a fine.
So what are we doing? What are we saying? If we are following the...
We could do an upper limit if we wanted to. We could. And so, for example, if it is that you wanted to take the approach in the Isle of Man, for example, the Isle of Man would have given on summary conviction to a fine not exceeding roughly about 2 million Jamaican dollars. And then you don't have a custodial sentence. You just leave it at a fine.
That's what I was thinking, that
yes.
we have a ceiling.
And then on indictment, in the Supreme Court to a fine, and then you allow the higher court, which is the Supreme Court, to determine the fine based on the gravity of the offense, essentially, or the gravity of the circumstances, I'm sorry.
Members, there are only 3 amendments left to complete this, so I'm just going to ask your patience, your forbearance to go through these 3 remaining amendments. Clause 31, huh? No, it's not 3?
No, and they have some other agency matters.
Oh, this is the ministry. All right, let's complete the ministers. Clause 31, please, Ms. Murray.
So members,
Yes.
All right, so, well, let me put it again. So we're agreeing to a fine and a ceiling of $2 million Jamaican.
It would be $2 million at the parish court on summary conviction. That was the record. That's the suggestion, member. So it would be to a fine not exceeding the sum of $2 million on summary conviction in the parish court. And if you're convicted on indictment in the Supreme Court, then you leave it to a fine, and then the judge determines based on the gravity of the circumstances presented before him or her what the fine would be at that point in time. It's
Ms. Murray? Ms. Murray, clause 31.
so on the matter of clause 31, members would recall that the concern raised by the FID that they would be constrained by this provision if they had to determine adequacy in relation to another jurisdiction to which they would have to transfer or would be required to transfer personal data. We did some research to determine whether any jurisdiction made specific provisions for law enforcement purposes, and the findings are outlined. We note in Argentina that they would, so this is in relation to cross-border transfer and transferring personal data outside of the jurisdiction. And so in Argentina, for example, they make an exemption for the transfer that having to do with international cooperation between intelligence agencies engaged in combating organized crime, terrorism and drug trafficking. Australia didn't use those types of, well, certainly not a specific, no, well, not a specific reference to the types of activities, but would have made an exception for disclosure by a government agency that relates to foreign law enforcement activities. So we note that exception within the context of Australia's Privacy Act. In Brazil, they made an exception for transfer where it was necessary for international legal cooperation between public intelligence, investigative, and prosecutorial agencies. The UK also has, well, in fact, the UK has an entire part which transposes the law enforcement directive of the EU and essentially creates a data protection regime specifically for law enforcement personal data processing. And Ireland has adopted a similar approach as the UK in relation to transposing the law enforcement directive in the EU. Israel also allows for transfer where it is vital to public safety or security, that's the language they use, or required by Israeli law. And other jurisdictions speak broadly to an obligation under an international treaty. In Mexico, for example, they speak about pursuant to law or treaty to which Mexico is a party. And In Morocco, we note the transfer is allowed where it is required for performance of a task of public interest or related to the exercise of public authority vested in a person in charge of processing that data. Peru, another Latin American country similar to Mexico, uses language in keeping with international judicial cooperation, international cooperation among intelligence agencies, and would have listed quite a number of things that would have captured terrorism, drug trafficking, money laundering, etc. And Qatar does something similar as well. They speak about transfers where it is necessary for compliance with any legal obligation to which a data controller is subject, and transfers that are necessary in relation to compliance with auditing, accounting, or anti-money laundering obligations. And just to point out that in Qatar and the UAE, they have specific legislations related to their free zones. So that would be what is affected there. And of course, Russia also has an exception that allows for transfer in relation to state defense, security, and transportation system. So we found a couple of jurisdictions that have a carve-out and that allow for transfer in the context of national security law enforcement and in relation to treaty or agreements that might be entered into between countries in relation to the, just generally treaties, and then of course adding language that would allow for law enforcement agencies to transfer data.
What is the recommendation, though?
So if the committee is minded, it could add language to treat with the concern that was raised by the FID, to add language that would exempt, would allow an exemption for cross-border transfer of personal data in instances that are related to intelligence investigation or law enforcement.
Okay, I remember Senator Charles, this was a particular one of yours. The ministry has gone back and done the research, and they're saying they could add language to allow exemption of cross-border transfer of data related to national security issues. Right, Ms. Murray? National security. All right, I put clause 31 to committee members with the exemption, the language to allow, with the amendment, sorry, which is the language to allow exemption of cross-border transfer of data related to national security. We'll be adding that language.
Adding the language, and then you'll see what that is when the CPC returns.
Right. Okay. So I put the amendments to clause 31. If there are no objections, we accept clause 31. Just want to recommit clause 23 again, just to be clear on what it is. I'm putting to the committee members that the fine and sealing of $2 million on summary conviction in the parish court, and that the Supreme Court judge can determine the fine based on the gravity of the circumstances. So I put clause 23 to members. If no objection, clause 23 is approved. All right, so we move on to the final comment from the ministry, clause 65 and 66, I believe. No, sorry, second to last, because there is clause 67, and that would be the final, well, 67 and clause 70, sorry. So clause 65 and 66, Ms. Murray?
Thank you very much, Chair. I believe that the committee would have agreed to accept Clause 65. I think the concern was in so doing whether or not Clause 65 and Clause 66 could be merged, given that they were talking about prohibitions in relation to providing records, whether records on the basis of providing goods and services or records on the basis of health records for employment purposes or other purposes. So we will deal with the more substantive issue, which is Clause 66 first, because that deals with the terms in contracts which say that you cannot require someone to produce a health record as a term and condition in a contract. This particular clause, we noted, was similar to a clause in the UK's Data Protection Act of 2018, which similarly makes void any condition in a contract which requires a data subject to produce a health record. What we found was that this particular clause replicated a clause in the UK's Access to Health Records Act. So they have a specific piece of legislation which gives to what we now call a data subject or an individual the right to access one's health records. Prior to the Data Protection Act of 1998, what we found was that that was a legislation which allowed you to access health records of persons who are living and persons who are deceased. However, with the new data protection regime in 1998, it removed the right of access for living persons and made that right of access a part of the data protection regime. What we've been talking about for the last few months, which is basically if you want to have access to the records, the data subject is the one who essentially would be making that request, and we're making that request subject to the terms and conditions or the rights that he or she has in the Data Protection Act. As a consequence of that, the access to health records legislation only now covers deceased persons, full stop. And why is that important is because as a corollary, what the UK also has is an access to medical records legislation, which allows insurance companies and which allows employers to be able to get medical information on a prospective employee or prospective insured, but with that employee's or insured's consent. And with that employee or prospective insured being able to withhold consent or to indicate very specifically that I want to see the medical record before it is shared with the employer or before it is shared with the insurance company. So what the legislation sought to do, the provision I should say, sought to protect that particular right. And just to be clear, if it is that the law says that an insurance company or an employee must get the consent of the employee or the prospective insured before medical information is shared, then you didn't want a situation where they could circumvent that requirement by putting a requirement in a contract to say, you go and ask for your medical record and then carry it to me. So in other words, I'm not going to ask for it and then get your consent. I'm telling you that I would like you to go and get it and bring it back to me. And so this particular term in the data protection legislation was to ensure that contracts did not contain a clause which would require you to use your subject access rights to be able to go and request your medical records and then hand it over to an insurance company or to an employer when there was a very specific piece of legislation which provided safeguards as to how that could be done if you needed those types of records. Having looked at it, the ministry is of the view that we should retain a similar provision in our legislation. We recognize that currently we do not have any specific legislation that deals with access to medical records. We operate based on the common law system in terms of the fact the doctor-patient relationship and how that would operate. And the Ministry of Health has advised that there are some draft code of practice that they have developed which will deal with how it is that a patient can access his or her medical records and how that record can be shared and to whom that record can be shared. However, we are also cognizant that once the legislation is passed, that there are going to be regulations specifically related to access to health records. And we would have shared that throughout this discussion that our consultation with the Ministry of Health was that they would have wanted, or it would have wanted to have companion legislation to deal with access to health records. And when we looked at the similarities between what it wanted to do as a substantive piece of legislation and what we're doing, the recommendation was regulations. So just to put it in context, even though we don't currently have similar laws that deal with access to medical records, or we don't have similar laws that protect or put in context, allow insurance companies and employers to request your medical records with the consent of the data subject. Those will be coming in regulation shortly, and so we believe the safeguard needs to be here so that an entity does not use a data subject access rights to say go and get the information and bring it to me and then circumvent anything that comes thereafter. That is what we saw in the research out of the UK, and we found that it was very similar in the state of Jersey as well as in the Isle of Man as well.
So the recommendations
is to keep. Thank you, Chair. The recommendation is to keep Clause 66, and because of the nature of the right that is being discussed in Clause 66, very specific to protect health records, we do not believe it should be merged with any other right at all. And also, we did in the 3 jurisdictions that we researched, which had a similar provision, they did not merge the right. They were similar, but I'm sorry, they were similarly placed, but they were not merged at all, and we think we should keep it separate.
Just for clarification, so a situation wherein someone wishes to take out a health insurance policy, that would be covered under 65?
If you're willing to, and I'm gonna take it one step further, because if you're willing to take out a policy and the health insurer says to you that you would need to go and get a medical done, at that point in time, what the insurance company cannot do is to say to you no, that as a condition essentially of getting coverage, you must go and request your medical records and bring it to me. However, they can, well, depending on what will be done through the regulations with health, is that there can be circumstances in which if they need information to make decisions in relation to risk, essentially, that they could send you to a list of doctors to say, go to this doctor, for example, and the doctor, and there's been a patient-client relationship, and then you go to the doctor does a medical examination, and can indicate certain very specific things. So if the risk they need to know is hypertension, they can say, yes, you have hypertension, but they may not necessarily speak to all of your medical information, because there's no reason for the insurer to be in possession of everything. And that is a concern that we're hearing from the ministry about ensuring that there is protection of health information and revealing health information only to the extent that that information is necessary and required.
So if I go to open a life insurance policy or any insurance policy, and the provider says to me, you have to do a medical. If I refuse to do the medical, then they can refuse to give me the policy. I just want to know, they can refuse. And that's what obtains now. I'm talking under the Act. What's the new dispensation? So it will continue. And that will be treated, just a minute, and that will be treated on a 65 that says that it is needed for, where is it? B.
Yeah, but that has nothing to do with the Act. That is just what obtains with the health insurance company.
I know.
And they will then send you to a doctor if they're not pleased or they're not, happy with what you have possibly said to them. Maybe you had a pre-existing condition, they're going to actually send you to their own physician to do a medical. And if you refuse to do the medical, they have the right not to give you the insurance. But what this Act is doing is really to protect you. This is what I'm hearing, that they can't tell you that you need to go and get your data and then bring it back to them. Isn't that what that's what you're saying essentially?
So just to ensure that...
Before you answer, because I don't think Juliet understands. I know what presently obtains. I'm just trying to figure out if tomorrow this bill becomes law and you go to the insurance company to take out a life insurance policy and you say, but there's a law that says you can't have to do a medical record. Does the insurance company have section 65 2B as their defense? That's all I'm trying to find out. Which says, in the particular circumstances, the imposition of the requirement was justified. Well, no, that says public interest. I thought it said in the particular company's interest. Pardon?
No, but they can ask for a medical record because you could give it on consent. What this is saying is it can't be done without your consent. That's all this is saying. This is not stopping them from asking you for it. So they can still ask you for it. You can provide it with your consent. They just can't go behind your back and try and get it without your consent. That is what this is, right?
I know that. I'm just
This is what this law is saying that as well.
I know about the consent. I'm just asking in terms of an individual, any man on the JUTC bus who here before had an issue with feeling forced to do a medical. Yes? There's no law that governs it, just a practice in the industry which one understands. What I want to find out, when this becomes law, is there any defense that the insurance company will have to say, I am right? It's either you do the medical or you don't do it and you don't get an insurance.
But remember that...
Chair, if I may, I think I just have to reiterate what the SG just said. This law would not affect that at all. And we have to go back to, I think there might be a little misunderstanding. We have to go back to what the regime in the UK was all about, actually. And perhaps the ministry didn't go far enough what they said. What the Access to Medical Reports Act does, right, and if I can just read the long title, an act to establish a right of access by individuals to reports relating to themselves provided by medical practitioners for employment or insurance purposes and to make provision for related matters. As it stands now, if for employment purposes and for insurance purposes, once you go to whether it is your doctor or some other doctor provided, requested by them, that medical report is not typically seen by you. It goes straight to the insurance company or to the employer. What this act sought to do was to, one, make it, you have to give explicit consent. Secondly, you would have the option of seeing that report before it was sent and to make corrections. It also gave the doctors a statutory duty where they, in their view, they felt that the information there was somehow called to your best interests not to provide that information. Yes, it was not really aimed at insurance companies or employers and preventing them from accessing medical records. What it did was give the individual the right to do that, which is why I was going to make the comment that this section by itself actually doesn't do very much without that surrounding framework. And so, in fact, I'm made to understand that it is considered that regulations may be sufficient for this. I can't say at this point in time, but without that framework that gives those rights and sets out what those rights are to the individual, this section by itself actually doesn't really do very much. And in fact, it falls under the general provision of the Data Protection Act, which is that you must give consent to whatever is being requested of you in relation to your personal information.
The question that is being raised is a relevant one, just perhaps not as relevant in relation to this issue. Is that what you're saying?
No, it would still be relevant, and that's what we were pointing out at the beginning.
So
and
does it change or adjust anything that you have done in the analysis?
No, it doesn't. No, it doesn't.
So we could determine then, in relation to this specific section, whether we are agreeing or disagreeing, and always still come back to this very relevant question, because
it's 5:23.
Through your chair, no, it doesn't change, and that's why we said earlier, and that's so, and I thank the LRD for that, because that was the point that we were making earlier, that essentially they have a regime that deals with this particular thing, and the Ministry of Health has indicated that a similar regime is required for Jamaica, and they have seen at this point in time that they're going to choose regulations to deal with it and provide those type of safeguards essentially. Similar thing as to who will have access and how will you have access essentially, and how will the data subject have access to information that persons have about them, which is a similar regime that the UK have, and that's the information that we have here. Well, that's the recommendation, but I take the point from my colleague that at the time when it is coming, we'll have to assess the adequacy as to whether or not the regulations will do all of what it needs to do, and then determination will be made as to whether or not any other substantive law is required to support it or companion legislation.
So I put clause 65 and 66, the committee members, the ministry is recommending that clause 66 be retained in the legislation and that clause 65 and 66 not be merged. And those are the two recommendations. There are no objections. We'll accept those recommendations for clause 65 and 66. And then we just have two more from the ministry. Clause 67, disclosure of information. And clause 70, liability of body corporate. What? Oh, 63. We did 63 already. Or did we committed? We recommitted.
It's not in this.
Oh, okay.
At clause 67, some concerns would have been raised by the committee in relation to the concern was really around what seemed to have been a very wide provision that allows the commissioner to be able to, notwithstanding any enactment, require information from anybody actually. And the research is set out there. It's, we found 3 countries, Isle of Man, Jersey, Barbados, which have similar provisions to ours. We know the Bahamas and St. Lucia expanded the section to take into account matters of national security and safeguarding the security of the country or information privileged from disclosure in court proceedings. The UK gave some exemptions as well for disclosure prohibited under sections related to security, its Investigatory Powers Act, and in Cayman, an individual should not be compelled to disclose anything that may incriminate him or her. The GDPR generally stipulates that the powers conferred shall be subject to appropriate safeguards. So from the analysis, some jurisdictions broadly address the matter of disclosure of information to the Information Commissioner, while some give exemptions for matters of national security. The Ministry is therefore of the view that, that it is important for the Commissioner's function not to be impeded by any other legislation. However, if the committee is minded, an exception could be made for matters of national security, information before the courts, and self-incrimination. Or to the legal reform department and the AGC.
The Chambers doesn't quite share the view of the ministry, and we don't support the approach. I will take you first to the Access to Information Act. Now, under the Access to Information Act, you have exempt categories. So there is a general, and if you go to the objects of that act, it is dealing with, the whole point of it was for transparency and even accountability. Because if the public can access public secret documents held by public authorities, the aim is to allow for not just transparency but accountability, because then you're going to be able to examine the operations of all these public entities. That act, so the first issue is it allows for access. It then goes on to say that there are some categories that are exempt. That act also goes further in section 35 to say that it recognizes secrecy provisions in other acts. Because you have to understand that when Parliament passes a law, Parliament is going to be looking at a regime for a specific, it could be an entity, it could be an enterprise, and it will determine what it thinks is needed to operate that entity, that enterprise, that activity. And for some of those matters, you will find secrecy provisions. So the ATI Act did recognize that you will have these other secrecy provisions, and it was not going to override that. I can give you 2 examples. So in the Revenue Administration Act that deals with taxpayer information, it doesn't override it. So that is just one example. So again, a reason I'm raising the ATI Act, because it must be seen as a sort of companion measure to the data protection. That is how usually we have these laws that we look at as companion measures. Maybe not in the strict sense of how in the legislative framework we call a companion measure, but they relate to each other. There are certain matters that even if you wanted to have a broader approach with the data protection, there are still other matters that you have to have regard to. Our court has recently indicated that legal professional privilege is actually a fundamental right. It actually said so. The court has ruled that. And in our jurisdiction, that has been a ruling in other jurisdictions for years now. If you go to Canada, Ireland, the European Court of Human Rights, they have called it a fundamental right. It's supposed to be non-violable. It's not protected under this. Legal professional privilege is not protected here. So I would suggest that even if you want to have a broader approach, there have to be other categories that have to be exempt. Matters relating to the defense of the nation, international relations, these are some basic major areas that we think would have to be exempt. I would again also caution the committee. There are some other pieces of legislation that have their secrecy provisions for good reason and only allow sharing in very prescribed and circumscribed ways. Again, under the Revenue Administration Act, nobody can just go and get all sorts of information. There are some matters where you have to, some other pieces of legislation, you have to even go to court to be able to access information. So I'm just saying you would have to be very careful about how you approach this matter. But we don't accept the broad sweeping approach of allowing all this information to go to the Information Commissioner. And this is not now doubting the integrity of the the Information Commissioner. This is a bigger issue than that.
Chair, the challenge I'm having with this, however, I'm not seeing it necessarily as the commissioner having carte blanche control in this scenario, because what I'm seeing here is with any information necessary for the discharge of the commissioner's functions under this act. So what is the commissioner's function under the act? And what are those pieces of information that would therefore be necessary for the discharge?
So the thing is, it's wide.
Okay.
When you talk about the functions of the commissioner, it could be wide. It could be that even under, let's go to the commissioner as well. Remember now, the act though talks about it's information in a very, I know it says personal information, but it's almost any and anything that touches and concerns a person, an individual. To me, when this talks about necessary for the discharge of the commissioner's functions, it's still not restrictive enough. The commissioner's functions are, let me go. So, so for instance, even in terms of monitoring compliance with the Act, which is a very wide and vague function, which it needs to be. When the commissioner is going to monitor compliance, it means that the commissioner could be asking for information to be provided by a data provider to see how that data provider has been complying with the act. That data provider, if that data provider is a law firm, how does that data provider, that law firm, comply with that request? Is it going to breach legal professional privilege to do so?
Or even if you receive and talking about your source as a journalist, for example.
In this case, therefore, I think that what we want to achieve must be clearly delineated, because here we have an exit into all sorts of things when we have information necessary for the discharge of function. The commissioner may have that leg room to make a determination as to what is necessary, and just may say this is very necessary in order for me to be effective in my function. So I think this must be clearly prescripted.
But how would we, because it appears that we are all agreeing, right? It appears we all agree that there needs to be some exemption for national security and for information before the courts, as well as self-incrimination. That said, do we define that wording now, or do we accept it and then go forward?
But I am saying that I don't think that. So how would you deal with taxpayer information under that?
So you're saying you want to widen this?
So for instance, the MAJ had a proposal which said unless permitted or required.
No, SJ, hear me now. What I'm asking is this, because I am persuaded by your submission. I'm just saying, what would be the wording of what you have presented? Since it doesn't fall within the three categories of national security, information before the courts, or self-incrimination, you'd be adding other categories, if I stand correct. So what is that? So we can consider it.
So we had, for instance, suggested where a law prohibits the disclosure of the information.
Okay, so
where
similar
a
to
law prohibits that, if a law prohibits sharing outside of a, you see, it's difficult to say it that way though, because there are some laws that prohibit share. Well, it will say you can't share except say in certain circumscribed ways. So under the Revenue Administration Act, they can share if the minister allows it, if they get a court order. And what we're saying is we wouldn't want to.
You're saying you don't want to usurp other legislation.
That is the point. That is our point.
So
yes.
member Fraser Binns had pointed me to clause 67, 151 in our matrix, where the Media Association had put a recommendation. Would that be sufficient?
So that is what I was about to read when you had asked for some more clarity, that unless permitted or required by any enactment or rule of law, yes.
So one last question I would have, which goes to what Member Morrison was saying. If it is that we relate, SG,
Sorry, member.
yes,
sorry.
yes. Let's get to the solution. Because I have a 6 o'clock town hall. No, Port Royal. If we accept the construction as suggested by the Media Association of Jamaica, or something similar to that formulation, does it then mean we're not required to have the specific distinction of these three categories? We can simply, that would be an overarching umbrella of exception, because these would fall within that category.
Yes,
national security.
Except I would say I am not sure about LPP, just because legal professional privilege is specifically recognized elsewhere in the bill. I wouldn't want someone to have an interpretation that if you really wanted LPP to be included, you would have specifically mentioned it here, and you haven't. When
So
you have mentioned it elsewhere.
Would you want to say then national security, information before the courts, self-incrimination, LPP, and on other?
No, I don't think we would need national security, for instance, because rule of law, or unless permitted or required, would cover, to me, those types of matters. And if it didn't, there is other recourse to the court for, say.
So you want us to leave it to CPC to
yes.
draft this?
Hmm?
Since it appears we're all agreeing. Dr. Zara Oliphant. You're a doctor of what? Zoology. Wow. Adam said.
We stray, Senator.
No, I asked. I just asked.
What?
Yeah, and we were, yeah.
Agreed on the essence of what we want.
Yeah.
And we can go to the last.
Okay,
And go to the
CPC.
last one.
We will leave this to your learned friends. Okay, the last, well.
So clause 17.
Sorry, hold on. Yeah. Clause 70.
Yes, members will recall that there was a recommendation from the committee essentially that we include, make that provision a little wider to include total worldwide annual turnover. We consulted with tax administration of Jamaica, not of Jamaica, anyway. And they advised that if we use language to the effect of gross annual turnover for the preceding year of assessment in accordance with the income tax, then that would be workable, because they currently assess worldwide turnover for worldwide annual turnover for companies that are incorporated in Jamaica. And then they go on to advise that if there are branches or permanent establishments that are only registered and not resident for tax purposes, then of course they could attribute those income to Jamaica. So it's, in a sense, what they indicated to us was that a language in akin to what the committee recommended in terms of worldwide annual turnover could actually work, and they would be able to determine what that is. I think that was the concern of the committee. Would we be able to capture and determine what that is? And the TAJ has indicated that based on their own assessment of how they assess tax, they could do that as well. But they would wish this language to be what we capture: gross annual turnover for the preceding year of assessment in accordance with the Income Tax Act.
Wonderful. I knew TAJ could do it. Members, sorry, we skipped over one little clause, 63. Yeah, we did, unfortunately. Unlawfully obtaining, disclosing personal data. Okay, that's for the AG's chambers. That's for AG. All right.
Simple, because we didn't get a rationale for it, so we were saying delete. But there was no rationale provided, so we had asked for the rationale for it for 63.2A. So this is why maybe it shouldn't be left to us. If there is no rationale for it, we don't see why it is being included. But Chair, we have 3 matters.
Go ahead, CPC. I mean, AG. Sorry.
So,
Chair, we are looking at clause 71. specifically, the MAJ had suggested that we insert pecuniary before the word damage in 71 subclause 1, and they made this recommendation based on a UK case where the term damage was determined by the court to be limited to pecuniary loss. The provision that they were looking at in their, I think it was a 1988 UK Data Protection Act, is the same exact wording as our section or clause 71. And so their reasoning is that in Jamaica, the court would likely take a similar approach to that interpretation. So we agree that that case would be persuasive in our jurisdiction, but we would want to know what is the policy behind it. Is it that the intention is to limit it to pecuniary loss? If so, we don't have any objection to inserting the word pecuniary there. But if that is not the case, then perhaps you would want to consider defining damage in that section so that it's not left to an interpretation that you would not want. And in the current UK Data Protection Act, they actually did define damage.
Ms. Murray? AGC is saying that we insert pecuniary before damage.
Or reaction members would be to leave it at large for the court to determine. Again, we're embarking on very new ground, and we really believe that the jurisprudence needs to evolve, and the court should be left to determine some of these matters rather than constrain. Yeah.
Chair, the other issue was with respect to the information commissioner and whether the information commissioner should be given the right to apply to be a party in proceedings. We did some research, and under the civil procedure rules, part 56, one of the persons who can be added to a party, to a proceedings, would be any statutory body where the subject matter falls within its statutory remit. And the IC, being a body corporate, would be a statutory body which falls within, and IC matters, data protection matters, would fall within the remit. So the long and short, we would not advise for any specific provision to allow for the information commissioner to apply to be added as a party, as it's sufficiently covered under the civil procedure rules.
So was that specific to a particular clause?
Yes, it was clause 61. But I think the general discussion was, do we need to include a provision there or have a separate provision that gives the information commissioner the right to apply to be a party to proceedings? And we're saying it's adequately captured in the civil procedure rules. So no change. Yeah, so we're not recommending a change or an insertion. And then the final one was in relation to clause 74, whether the act binds the crown, and the concern raised by the stakeholders was with respect to the crown exempting itself from prosecution. Because under 74.3, a public authority shall not be liable to prosecution under this act. And we had indicated the last time that the challenge with prosecuting the crown is based on how a public authority is defined in the bill. So they don't really have personhood. It would be a ministry, department, agency, etc. And the case law supports our view with respect to the practicality of prosecuting the state. But in terms of addressing the issue of accountability, there is still liability from a civil perspective. So if a public authority breaches a person's rights, they still can apply based on the Crown Proceedings Act to initiate proceedings against the state. And there is also, I believe, clause 63, which speaks to unlawfully obtaining or disclosing personal information. So if an employee of a public authority, for example, contravenes the provisions of the bill, they could be prosecuted under clause 63. So there is accountability. It's just that in terms of prosecuting the state, it's not a feasible solution.
There is other accountability too that is always overlooked and sometimes minimized, but it shouldn't be. And that is leaving a civil servant liable to disciplinary sanction. It happens, and it's not something to be discounted. And the range of sanctions lead from, as minor as a reprimand to a fine, all the way to suspension to dismissal. So there is also that level of accountability, because if a civil servant acted in a manner inconsistent with the act, action could be taken against that civil servant from that perspective as well.
So the long and short of it, Chair, we are not proposing an amendment to Clause 74.
No amendment to Clause 74. No objection. We accept Clause 74. All right, ladies and gentlemen, we are indeed at the end of this session of the Joint Select Committee. In terms of the go forward from here, Parliament will prepare a report reflecting all the amendments. We will have a meeting or two to discuss the report. CPC will also do a document.
The general report.
General report.
The general comments that were made by stakeholders. Ms. Muller was just pointing that out.
I'm sorry, Ms. Murray, you had something?
Chair, you'll recall, the committee will recall that what we've presented are comments in relation to specific clauses. So there were some general comments that were made that are not related to specific, and those will have to come.
So, Ms. Murray, are you saying we have to have another meeting?
Yes, because there are comments that have been made and recommendations have been made to, for example, introduce new rights that would not have been addressed in the current bill, and persons are recommending different things. So we want to, and that is exactly what we have done and will present to the committee. But that's the last set of things to do, committee members. But we think we need to respond, yes, as fulsomely as we would have done for others.
All right, thank you for that. So we will meet another time. But following that meeting, Parliament will prepare a report. CPC will also do a document outlining all the changes. The parliamentary report will reflect those changes as well. The committee will meet to discuss the report. I don't know how many meetings, but we will meet to discuss the report. When the committee approves the report, the bill will be tabled. The report will be tabled in Parliament, in both houses, for debate. All right. So I want to thank everyone. I want to thank the members of the committee. I want to thank the Office of the Parliamentary Counsel, the Attorney General's Chambers, the Legal Reform Department, the Ministry of Science, Energy and Technology, and the Houses of Parliament. It has been an eye-opening experience for me to have chaired this committee, and we look forward to bringing it to its conclusion. Thank you very much.